Well, estate planning is the process of transferring your assets upon death, or planning methods to transfer your assets upon death. It also includes generally incapacity planning, which is done in order to avoid the lifetime probate process that happens if somebody becomes incapacitated during their lifetime. The incapacity planning documents are a power of attorney and an advance medical directive. Those are typically also done under the umbrella of estate planning. Well, for incapacity planning, the power of attorney and the advance medical directive. For estate planning, really the primary document used is the revocable living trust, which avoids after death probate. Just like the power of attorney and the advance directive avoid lifetime probate, the revocable trust avoids after death probate. A will, unfortunately, is not a good estate planning tool, as most people think, because a will puts your estate through what we call the nightmare of probate. I think a lot of people put off estate planning because they don't like thinking about death or their own incapacity. And a lot of people just don't think that they need to do any planning. They figure the law will take care of things for them. I think every adult over the age of 18 needs to have incapacity planning. The documents we talked about a second ago, the power of attorney and the advance medical directive. If you have a young family that starts having assets, accumulating assets, then they should start thinking about the estate planning using the revocable living trust to avoid probate. If you have a family with children, they need to have a will, because a will is the only document that can appoint guardians for young children. And older people over 65, should be thinking not just of estate planning, but also of long-term care planning. Yes, the most common mistakes are that people think that a proper estate planning includes a will along with an advance medical directive and a power of attorney. And that is probably the most common plan out there. But in my view, that's not really a proper estate plan at all. Because you have the power of attorney and the advanced medical directive, as I mentioned earlier, whose purpose is to avoid the nightmare of lifetime probate, which would be guardianship and conservatorship and the filing of annual accountings. And yet a will puts somebody's estate through the nightmare of after death or post-mortem probate. And so most people make the mistake of just using a will when what they really need to use is a living trust to avoid the nightmare of after-death probate, just like they do the power of attorney and advanced medical directive to avoid lifetime probate. A will is a last resort method of transferring assets upon death if somebody dies owning assets in their name alone. There are many ways of avoiding probate. One method that some people use are beneficiary designations, for instance, on retirement plans, on life insurance policies. The other method, and the best method for most assets, is the revocable living trust. The way it avoids probate is that the trust is a document that is created while you're alive. It's actually, the document creates an entity that is capable of owning assets. And those assets then get transferred from you as an individual into your trust, or you as trustee of your trust. You retain full control over those assets, but upon your death, the trust does not die. The trust can remain alive indefinitely and can even protect your assets for your children and grandchildren down the road. And all of that is outside of the court-supervised probate process and the nightmare of probate, which involves filing accountings with the court and filing inventories with the court. And these accountings have to be filed every year as long as a probate estate is open if you don't have a trust. So a lot of reasons that people should be using a trust as their primary estate planning tool and not a will.